Hi, my name is James Phillips. I am an attorney, and I specialize in basically military law. I do all kinds of military law. I've been doing military law for about going on 14, 15 years now. I am a former JAG, and I was also been a civilian defense counsel now for a number of years. I don't just do court martials. I also do administrative separation boards. I do the Army Board of Correction military records. I do VA claims. I do all kinds of military law. But one of the things that I do and enjoy doing is court martials. And in the age of sexual assault allegations and maltreatment, there's a lot of work out there for court martials. So one of the things that I'm going to do today is I want to talk to you about what the process of going through a court martial is. And as I do, I'll go through and talk about some of the hurdles that you'll face and some of the things that come up. So the first thing that I want to get into is normally a court martial begins with some kind of investigation by either law enforcement, the chain of command, or some allegation that has been brought by a private party. And so the first thing that you need to remember is very early in the process, somebody is generally going to want to talk to you. They're going to want to come in, ask you about the offenses, ask you about what has happened, and they're going to want you to tell them the story. And one of the things about soldiers is soldiers generally really want to do what their chain of command is saying for them to do. A lot of times they don't want to piss somebody off. They don't want to get in there and say, I'm not going to talk to you, sir. But the bottom line is that when you came into the military, there are things called constitutional rights, fundamental rights that you have. And one of them is the right to remain silent. That is a constitutional right. It's a protected right. And you didn't waive it when you came into the military. It still exists. Even though you're a soldier or you're a service member, this is still something that exists for you and that you have to use. And here's why you have to use it. Because if you are trying to get yourself off the hook for whatever they're accusing you of, you're not going to do very well by talking to the investigators. Because the thing that you're going to do is you forget that one of the things that a prosecutor has got to do in order to convict you is, one, they have to prove that you were there. Two, they've got to prove that you knew anything about what was going on. Three, they have to go and they have to show that you had what's called mens rea, which is you had the intent to do whatever it is that you've been accused of. And the problem is that when you make a statement, even though you may be denying it, you generally will make statements along the lines of, I was there, but I didn't do it. And so you start going down and you start proving many of the elements of the offenses without even knowing it. Things that maybe if you had an attorney or you didn't make a statement, that somebody would be able to go in later and be able to shape the story and be able to put your side of what the truth is out much better than you can under the questioning of CID or the questioning of law enforcement or the questioning of the chain of command. So when you are read your Article 31 rights, your right to remain silent, anything you say can and will be used against you in a court of law, and you have the right to an attorney if you so want one, you should be asking for an attorney. Once you've been read your Article 31 rights, you have the right to go over to Trial Defense Services. You have the right to hire civilian counsel, and this is the time to do it. The earlier I get hired in a case, the more that I can do to help somebody. The biggest victories that we normally get as attorneys are when we've been brought in very early in the case, and we can help shape the way the investigation goes. Because even though you can't talk to the investigators, I still can. And I can suggest to them that maybe they're going down the wrong road. Maybe they haven't heard the whole story. And we can get involved as attorneys early on and be able to help the way that the case is shaped versus just having trial counsel or just having prosecutors shape all of the evidence that's being brought forward. We can even sometimes talk to your chain of command and calm everybody down, let them know you have a defense, we're going to fight for you. Things like that really can make a difference for the long-term part of your career. Now, what goes along with investigation is that certain kinds of crimes or offenses lead themselves to being offered a polygraph test. I will tell you right now that my advice to my clients is generally unequivocally do not take a polygraph. Polygraph are called lie detector tests. Well, they're not truth detector tests. So you cannot go in there with a lie detector test and expect that you're going to come out there and you're going to beat the thing. Because generally what will happen in a lie detector test is, one, you will either be declared deceptive, or two, you're going to be found to be neutral. And the problem with that is a lie detector test is not there to clear you of an offense. What a lie detector test is there for is to give the lie detector, the person that is the polygrapher, a chance to come in and do what's called, they basically do a post-poly interview. And a post-poly interview is designed to allow them to question you and get around your Article 31 rights and be able to come in and start calling you a liar. You were deceptive on your polygraph. Tell us why you're lying. We don't believe you. You were deceptive on that polygraph. You were lying. Tell us. And they will go through and get a second bite at the apple. And generally when people have been told that they failed the polygraph, they feel like the jig is up and they need to come through and come clean with everything. Well, that even though your polygraph is not admissible in court, and they're going to tell you that at the beginning of the polygraph, what is admissible in court is what you say. So a polygraph test is not allowed to come in as far as the results of the test, saying whether you're lying or telling the truth. What is going to be brought in, though, is going to be your statements. So if you say after it's all over, they say you're lying, you shot her, and then you came back and you say, yes, you're right, you caught me. That statement, even though the polygraph isn't allowed to come in, that statement's going to be allowed to come in. So you have to be very, very careful when you're dealing with polygraphs. And I would never, ever take a polygraph without having the attorney there, because the attorney can shape questions. And usually my advice to my clients is not to take it no matter what. There are some cases, very few and very rare, where a polygraph is worth taking, but you better have an attorney sitting there by your side when you're doing it. So what happens is, after all the evidence is compiled, we don't have, as the defense counsel and you as the accused, do not have any access to what's called discovery. That's all the evidence being compiled by CID, law enforcement, or your chain of command. So you can't get it. And you don't get it until after what's called preferral of the charges. So once a charge sheet has been created where all the charges are on there that the government is going to try to prove against you. They're called charges, and then underneath them there's specifications. So the charges are generally offenses that have occurred that fall in line with the Manual for Court Martials and the Uniform Code of Military Justice. So you have to look, it's no problem doing this. You can look up whatever they charge you with. If it's an Article 134 offense, if it's an Article 120 offense, you can look it up by yourself, going online, and figure out what it is they charge you. But essentially, the preferral charges is on that charge sheet. They're going to have the details of what it is they think they can prove against you in order to take you to a court martial. Now, today I'm talking about generally I'm talking about general court martial, but so I'm going to talk about an Article 32, but a special court martial does not have an Article 32, but is basically going to run the exact same way that a general court martial is, just without the Article 32. So the time that it takes to add, the Article 32 investigation, that is going to be something that you will not find in the special court martial. The Article 32 investigation is a preliminary hearing, and you are going to have an investigating officer that is there. It's supposed to be somebody who's neutral and detached, but that is not normally the case. It is going to generally be a captain or a major, and that person is going to investigate whether or not there is reason to go forward with the charges that have been charged against you. Now, let's be real. If you are at an Article 32 investigation, there is hardly ever a time that you're going to beat the Article 32, and the reason is because it's very hard for an Article 32 investigating officer to get rid of charges when he is being directed from above to investigate something that obviously at least the chain of command and at least the prosecutors in the case believe that there's enough to go forward with and to prosecute you. So generally what happens is that is that when we go in there as defense attorneys, it's an opportunity for us to look at the case. As the prosecution puts on their case and they're presenting what's called probable cause, which is the lowest level of the lowest standard of proof that's out there. It's not that high level of beyond a reasonable doubt. It's that lower level that is this probable cause. So the odds are that they're going to make probable cause. But from our purposes, it gets us a chance to look at the witnesses. It gets us a chance to look at things. And generally the defense it's a little unsatisfying for the client, because as we're going through, generally the defense is not going to put their case up at this point. They are not going to go in there and let the prosecution get ready for what's a coming. And one of the things that you do at the Article 32 is you go through, before you go in there, though, you look at all the discovery, and you're going to see the police reports, the statements that people made, the witness interviews, what's gone up to the lab, all those kind of things. It's also at the Article 32 a good time to normally start looking at whether or not you're going to need expert witnesses for the trial, things like that. Because once you've seen the shape of the case at the Article 32 investigation, you know going forward that this is what the trial is essentially going to look like, and we need to prepare for the defense. After that, the next thing that happens is it generally will go to the convening authority, who's going to be the two-star general in charge of your jurisdiction. And that convening authority, the General Court Martial Convening Authority, is going to decide what to do with your case. He's going to base off of whatever the Article 32 investigating officer does and what he has done in his recommendations are, but he can do whatever he wants. And so this is called referral. And once referral takes place, generally what has happened is the case has moved from the investigative phase and from the general's control, and now it shifts over to the judge that's going to be handling your case. Normally in the military, there's a thing called electronic docketing notification that goes out after referral. You're going to be presented with the referred charges, which shows what the general actually sent to the judge. And then from that point on, you know where the case is going to go. Once it's gone over to the judge and he picks a court date, he also is generally going to set what's called an arraignment. And an arraignment is pretty much a standard quick proceeding, and what that does is it sends your case and it puts you before the court. You generally have a chance to elect counsel at that point, whether you're going to go TDS, whether you're bringing in a basically a civilian defense lawyer. What you're going to do as far as your counsel is, you're going to have forum selection, you're going to be read the charges, and it's going to be a time that you're going to be able to present motions. You can also defer all those things, and you can do that later. And a lot of times in a big case, the judge will then set a later date for when motions are due and there are further proceedings. And then there'll be another date that comes after the arraignment. But one of the things that happens at arraignment is that if you have been arraigned on a charge, what has technically happened is you're before the court, and if you were to go AWOL after that, the trial could still proceed even though you were not there. Pretty scary thought to think that you weren't going to be there. So I'd never recommend it. I've only had one client that ever did that, and it was a nightmare. So going forward, from the arraignment, you normally have a date for motions. This is also time when the defense is still trying to put their case together. Sometimes we put witness lists. At this point, we can do a request for witnesses, start asking for the government to gather our written witnesses and send, get the people we need for trial. This is time you'll see motions to suppress, motions for a dismissal. If they denied us something along the way, motions to compel the government to give us expert witnesses, motions for them to be compelled to give us evidence, whatever kinds of things it is. At this point, we go to the judge and we ask the judge, we need you to do this. We need this, we need that. And so there's a lot of infighting that occurs prior to the trial and the trial date that's coming up, because these are things that we have to resolve. Even on the trial date, we can still resolve some things that are called motions in limine, which are motions which are designed to deal with evidence. Things like, we don't want this in, or the government says, we want this in, and judge, we need you to make a ruling beforehand so we know how our case is going to look. Once you have a trial date, there are several kinds of ways that you can go. If you are an officer, you can go with a panel, which is the same thing as a jury of officer jury, and you have to have at least 5 officers on that jury in order to go to a trial, have a quorum, what's called, or you can decide to have military judge alone. Your attorney will talk to you. There's a whole lot of different reasons to pick one or the other, a panel or a military judge alone. Now, an enlisted person will get a third option, which is they can have an enlisted panel, which means 1/3 of the jury members will be enlisted folks. They're generally going to be sergeant majors, first sergeants, things like that. But you're going to be able to have enlisted people look at your case and to balance out the panel somewhat. Everyone's going to outrank you, and there are a lot of considerations. In fact, this can actually be the most important decision in the entire case. Now, once the trial actually plays out, it looks pretty much like a trial that you would see on TV. You're going to have, you're going to pick a jury. If you got to pick the jury, you're going to see who you think's biased, who's not. You're going to then go to opening arguments, and then both the defense and the prosecutors are going to give the opening arguments. Government starts first, defense goes next. If defense doesn't want to give their opening argument right away, they are allowed to waive it until their case comes up after the prosecution's presented their case. Very rarely do we do that, but there are some special circumstances to do that. After the opening arguments, the next thing you're going to have is the government presents their case. It looks exactly like you would think. The government does the direct examination. They lead their witnesses through everything, and then the defense counsel gets up and they cross-examine. And the case is going to be many times won or lost based on what happens at the trial. Evidence is introduced. If there's some kind of laboratory evidence, that's all going to get. But all of this is going to be contested. Objections are made, and all of this is worked through as far as the prosecution's case. After the prosecution's case and after the government rests, the defense can make what's called a 917 motion, which is under Rules of Court Martial 917. And the bottom line is it says, hey, government, you failed to prove your case. There's some fatal error that you can't go forward. Very rarely are they granted, but every once in a while they are. And then once that's over, if the defense has reserved their opening arguments, they can now choose to either give it or waive it. And then from that point on, the defense begins to call their witnesses. This time they're not on the attacking mode. They begin to do what's called a direct examination, and they call their witnesses. They go through them, and this time the prosecution is down doing the cross-examination. We call our expert witnesses. We do whatever we have to create what's called reasonable doubt, and so that is the standard at the trial. We don't have anything to prove as far as the defense is concerned. That's not our job. Our job is to attack the government's case. But it's very nice if we can prove something and we can prove that our guy didn't do it. It helps. But many times cases aren't like that. Many times you're just simply punching holes in the government's case. Once we have presented our evidence and we are through that process, the defense will rest. At that point, the government has one more final chance to bring what's called rebuttal evidence, which is supposed to relate to the case that the defense brought. Generally, this is normally kind of short, but it doesn't have to be. I mean, the government, if they feel like the defense has thrown out all kinds of lies, can bring in their counters and fight us on it. Once that's done, we will then go to what's called closing arguments, and closing arguments begin with the prosecution. The defense goes in the middle, and then there's another rebuttal argument that the government gets to do. So the defense gets sandwiched at this point on the closing arguments. After that, and then at some point before the closing arguments, what called jury instructions will be read, and then some jury instructions will be read afterwards. And they're just instructions to the jury as to what they need to do and how they need to decide the case when they get back into the deliberating room. When we're done, jury gets up and leaves. It sits judge alone. He goes back to his back room. The court is closed, and we wait. And we wait what seems like an eternity on the defense, but When it's all over, the judge will come back, and the greatest feeling is when they come back and say not guilty, because if that's said, then we're just done. It's a great feeling. I have many not guilties in my career as a military lawyer, and it is just a phenomenal feeling when that happens. If you don't get so lucky, then you generally will be some mixture on the charges and the specifications. Some will go through, some will be amended. Whatever happens, you're going to have a changed charge sheet based on whatever the evidence is. The most unlucky result is they basically say you're found guilty of all charges and specifications. Sit down, you're about to get sentenced. So normally we take a few minutes after we hear the sentence, and we get ready for sentencing. At sentencing, you're looking for what's called mitigation. It still works the same way. The government gets to put on what they call aggravation. We put on mitigation. We still get to put on we get a soldier book. We call good witnesses to get up there and testify on your behalf. And this can really be a strong, powerful part of the case for the defense, because this is where generally the government doesn't have as much to go with as the defense. So the defense really needs to use sentencing as a means to lower the sentence of whatever is going to happen in the case. And so that's what we do. It's a big moment for us. After all that's done and we present everything, we give closing arguments. Once again, you have the prosecution going first, then you have the defense going, the judge or the jury, they leave and they come back, and then they give you your verdict of whatever it's going to be that you're going to be sentenced to. And then from that time, we move to a whole other thing, which is called 1105, 1106 matters based on RCM 1105, 1106. And we then begin to attack the case as far as appeals level. I'll talk about appeals later, and I'll even talk about 1105, 1106 matters later on down the line. But that's your general overview for a court-martial. If you are going through a court-martial, I would strongly suggest that even if you don't decide to hire civilian counsel and you want to just go with trial defense services, I would suggest that you just talk to a civilian defense attorney just to get an idea of maybe what his prices are, what he thinks about the case. Because one of the things that you can get with civilian defense counsel is you can get a person that thinks outside the box. And a lot of the civilian defense counsel have a lot more trial experience than the trial defense attorneys do. I am not a basher of TDS. I think they're good at what they do. Many times I tell people to go with TDS, but I think it's worth talking to a civilian counsel just to see what you get. The problem is you're going to have to find somebody that knows military law, because it's such a specialized area. You're really going to want to stay with somebody that is very familiar with this area of law. I handle these cases worldwide. If you wanted to ever call me, just feel free. You're actually got a link on this site to get a direct appointment with me, and so we can talk. I generally even call you on my cell phone, and we get right on it, because normally if you're calling me, we need to talk about it pretty damn quickly. So I appreciate you listening to me today. If you have any questions, just email them to me or call me, and I'd be happy to talk to you about either your case or just court-martials in general. So I hope you appreciated this video blog today, and just make any comments that you feel are necessary. Thank you very much.